You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. Here on Newsfile, we put Ghana first. And thank you also very much. Many of you very excited that we made good time for the specialists to speak to us about the COVID-19. And a number of you asking that we bring Professor Alex Dodu back to continue the education the way he has done. And all of you being full of gratitude to Kwame Safonga-Siedu as well. Now, we go to the Supreme Court, and joining me in the studio is Yao Pong, who is lawyer and senior lecturer, Ghana School of Law, and member Akufo-Addo's legal team. Yeah, thank you very much for making the time.
Good to be here. Thank you very much.
Also, joining us via Zoom are Dr. Dominic Ayine, who is MP and with the John Mahama legal team, as in those who have been helping to make the communication after the court. Oliver Mausi BARKER-VORMAWOR is researcher, Corpus Christi College, University of Cambridge, and Chief Technical Advisor, University of Ghana School of Law's Democratic Vigilance Project. Gentlemen on Zoom, thank you very much for joining us.
Thank you for having me. Thank you, Samson.
Great. Now, so if I may start with Dominic Ayine. Yesterday, you had yet another difficult time in the court. I suspect you may say that was not a difficult time. Naturally, it was supposed to be for your third witness to get into the box. He was only sworn in, and after that, no word. The whole day spent trying to protect your witness statement. The second petitioner, of course, the second respondent and first respondent together wanted as many as 23 of your paragraphs to be struck out. Somehow you succeeded in ensuring that only 4 of those paragraphs suffered. How does that make your case look going forward?
Thank you very much, Samson. And I think our case remains as strong as it has been. I want us to go back to something that you raised, an issue that you raised much earlier in the discussion about how this trial is proceeding. And that is in respect of how we managed the case management stage of it. That is a pre-trial. Of course, I am sure the respondents are happy that, these things are happening. But for us, if we had, pursuant to CI 99, had 5 days of case management, I'm sure what you saw, the drama that you saw yesterday would not have played out, and it would have been quicker for us with respect to, the cross-examination of our witness, and I'm sure would have been moving to the next, stage of the trial by now. Having said that, as I said, our case is, really very strong. Some of the issues that were struck out to us are germane, but they do not in any way diminish, significantly the probative value of what we are putting before the court. Now, if you notice, the objections were basically, I think, 2 or 3. First, that some of the paragraphs that were being attacked did not arise from the pleadings, or they were not based upon the pleadings, and then also that they were not relevant as far as the case before the court is concerned. But something you know very well that is a fundamental rule of law or principle of law, that you plead facts and not evidence. So, for instance, in a running down action, someone knocks you down. You plead the fact that you have been injured. Proof of the injury comes when you then present a medical report and you narrate how the doctors have examined you and so on and so forth. So for them to keep insisting that because we didn't say those things in our pleadings, we are not allowed or permitted, to, lead evidence in proof of those facts, it's a very strange proposition of law, because you know that, evidence is given to prove facts in issue. and not only the facts put forward by one party. All right. So, for instance, we have claimed that the chairperson of the Electoral Commission did not perform her constitutional duties, in accordance with law. We have cited Article 23, we have cited Article 296, and so on and so forth. And therefore, if, for instance, as in the case of paragraph 4, which was struck out, a witness called by the petitioner is seeking to prove that the chairperson did not, perform her functions as required by law, that is a material fact, which can be led in proof of the petitioner's averment that the fact that the petitioner put in his petition that she did not perform her functions in accordance with law. And in any case, this is a fact, an issue or a disputed fact, because they join issues with us in saying that the first respondent's chairperson performed her functions in accordance with law. Again, I can give another example. If you have a situation where evidence is led by Dr. Kwesa White in response to a question by petitioner's first respondent's lawyer as to why when they left the strong room, okay, whether there were journalists in the room, okay, and that they didn't leave their laptops in the room. And Kwesa White says no, there were no journalists in the room, all right. And when we left our laptops, we left, our items in the room because we intended to, come back. Now, evidence is being led, and he said there was just one person in the room who was, video recording everything. Was making a documentary, on what, was transpiring in the strong room. And so evidence is being, evidence is now being led in respect of this matter as in paragraph 5. And then you object to it on the basis that it doesn't arise out of, the pleadings. In any case, as senior, our, learned counsel, Tachuchikata, made clear before the court, you invited this evidence through your cross-examination. And when the evidence was given, it was not contradicted. Now, there is going to be a further affirmation of the fact that there was a gentleman in the room who was recording everything that was happening, and then you are objecting to that. Something, in any case, that documentary, the issue of the person recording, if the court is digging into the truth, because the court is now the investigator of facts, all right, if it's digging into the truth of what actually transpired in the strong room, it should be interested in calling for that, a video, a recording, okay, to be able to watch it and see whether or not, in the first place, whether Dr. Kwesa White and then Rojo Mitununu left their laptops, there, what happened. And for instance, I am sure if the recording is really good, you would see the movement in and out of the strong room for you, as testimony of the fact that, all right, they left because they were, instructed or asked to do so, and to consult with the petitioner before coming back to the place. So for us, the 5 that were struck out, we think they are relevant. We think they are material that could affect the probative value of.
Yeah, and that's the point, isn't it, Dr. Ayine, that if it is material, we also know by Abuaba versus Additional, that matter that if a matter is material to you, you plead it, and if you don't plead it, if you don't plead it, then you lose the opportunity of, as it were, seeking to smuggle it in your witness statement. And in one of the holdings, they said that the penalty for failing to plead a material fact is the exclusion upon objection being taken of evidence to establish it. And that's what they did. They objected to what you had not pleaded. And you are making the point
that principle that you have stated from the case, all right, is correct to the extent that we are dealing with an issue that is not arising from the pleadings. Now, if you are looking at, if a party did not plead the matter, all right, and there was no question of joining issues, because if we pleaded something and they joined issues with us, you cannot then say that going by the principle you have stated, we cannot lead evidence to prove the material fact in issue. There are two. I think our situation is distinguishable, right, because we are dealing with a situation where they have joined issues with us. So, for instance, I'll give another example.
Let's deal with what happened earlier, which got a lot of attention and got your team angry to a certain point, where there were commentary to the effect that the court was not being fair to you. Yes. You were seeking to have discoveries made and asking the Electoral Commission to bring you the originals of various forms, if you like, pink sheets, right? And the court said you can't have your way. The respondents opposed that, and the court said you can't have your way. And after court, all of you were here saying that the court was unfair to you. How so?
Well, we said the court was not fair to us because we think that discovery or the production of documents, I mean, under Order 22 of CI 47, is a mechanism for unearthing the truth. And we, deem that as an important mechanism for us. The court, took a very ambivalent view of the role of CI 47 in these proceedings, by citing CI 47 in these proceedings, by citing CI 99, the strict timelines provided by CI 99 as the basis for us not bringing these, applications. All right. And that is why we thought that it was unfair, because at the end of the day, discovery or production of documents is in aid of the trial, and the expedition, not only in expedition of the trial, but also in, getting to the truth of what actually happened. And that is how come that we felt, it was unfair. Now, people are contrasting that with yesterday's proceedings and saying, so now when it is not, against you, you think that the court is, being fair.
Yes.
We objectively assess each, day in court. And we say what we say based upon what transpired in court.
Right.
All right. We didn't say yesterday that the court, just because the court accepted not to strike out 23, of the paragraphs. The court has been as a whole. In the
2013 petition, there were 9 judges. The 9 judges unanimously dismissed a similar application. And they dismissed it on the basis of Section 166 of the Evidence Act. I want to refer to that and then ask you where you think the unfairness is. Section 166 of the Evidence Act says duplicate sometimes treated as original. A duplicate of a writing is admissible to the same extent as an original of that writing, unless a genuine question is raised as to the authenticity of the original or the duplicate, or in the circumstances it will be unfair to admit the duplicate in lieu of the original. This is what they have simply done, and which they have been upholding over the period. You didn't submit any duplicate and told them that there were problems with the duplicate, so the original should be produced. In 2013, they said the petitioner, that is Nana Akufo-Addo, Bawumia, and Jacobiche Bilamte, they had all their pink sheets with them, and therefore they will not be giving it through the Electoral Commission. So nothing changed. Why are you unhappy?
No, Samson, this is a different case altogether.
How?
If you come, I'll come to that. If you compare the reliefs that were being sought in 2013, right? They were, talking about pink sheets with same serial numbers, overvoting, non-signature, and so on. All right. Now, if you look at the pink sheets that were the duplicates, you could find on the face of these pink sheets whether or not someone signed or did not, a presiding officer signed or did not sign. You could determine overvoting on the face of the pink sheet and so on. And so looking at the peculiar circumstances of that case, the Supreme Court came to the view that Section 66 was of the Evidence Decree was, of the Evidence Act was applicable because the duplicates in those circumstances may be treated as the originals. All right. Now, take our relief relating to the declaration. Okay. Let's take the relief relating to the declaration. We are seeking a declaration from the Supreme Court to the fact, to the effect that when Jean Mensa declared Nana Addo Dankwa Akufo-Addo president-elect, all right, she did not do so in accordance with the Constitution, and therefore the declaration is unconstitutional. We don't have the documents relating to the declaration except maybe CI 135, which is a public document. All right. On what documents did she, for instance, we don't have form 13. All right. We don't have form 13. We don't have, except what they have, provided as an attachment to the witness statement, we don't have form 13. We don't have the documents, the originals, we have neither the originals nor the duplicates of the corrected, figures that were made by the EC. Something, you can't correct a presidential election through a press release. Okay, this is a formal process of recording the votes.
So Dr. Ene, thank you.
Original documents.
Thank you. Hold on there. Let me bring in Yao. So starting with, we'll come to the third witness, which you guys are clear in your mind. It is only intended for damage control because you believe that Dr. Kwesa White was so damaged to the point that if they didn't make this move to try and prop him up, their case was in trouble. The point about they being denied the discoveries, there are many people who don't understand why they were denied, because they say the EC actually issued a statement and said it has all its documents with it, and anybody who needs it at the appropriate time should just follow due process and they will give it to them. They first filed it to the EC for mutual discovery. The EC didn't give it, and that's what compelled them to now go to the court and ask the court to compel the EC to give it. What's the big deal about that?
Well, first of all, good morning to everyone. I will answer the question to the extent that it relates to my client and not the EC, with all due respect. But permit me to just start with one of my favorite quotes. The rules of court are not ornamental pieces. They are meant to be complied with. And this is the favorite quote by Her Ladyship by the Akutu. It was Akutu Banfo. In Patrick Akumenyi and others, and Hannah Bockman and others. The rules of court are not ornamental pieces. They are meant to be complied with. So before you bring any application, as we all know... You're
quoting from your own book.
Well, I understand there is nothing more hilarious than reading from your own book.
Yeah. Okay.
So anyway, so you see that before you bring an application, first you must arm yourself with the rules and understand the circumstances of the application and the rules under which you are going to apply or make the application.
Before talking about the rules, the question is, why was the Electoral Commission hesitant to give those documents?
Well, I have said
because
that...
after all, it had told the whole world that these documents were with it, and anybody who wanted it could come for them.
Well, I've said that I don't speak for the EC, but even on that point, when they say that anybody who wants copies or who want the documents, they are not going to give them the originals. They are going to give them copies. And those copies, quote and unquote, in terms of probative value or weight, it is even less than what had already been given to the parties. Because that one, the carbon copy, I would say that's carbonized.
Don Kayini is saying they didn't have some of those that they were
asking even for. Those they had, carbonized copy. And everybody knows, this is the document, there is a carbon inside. The very thing that is on the original also appears on the carbon copy. So why are you also asking for carbonized copies. Because when the EC says that come for some of the documents that you demand or require, they are not going to give you the originals. And if they give you that, even in this a photocopy, you cannot say that you have been denied opportunity to access the document.
Yeah, so the rules are not ornamental pieces. The rule says when you are coming to court,
yes,
you bring what you have,
yes,
however faint.
Yes.
Then you may ask the one who has it or who ought to have it to now supply it. And then you could also ask for what you don't have, but which you must have. They are saying, forget about those we have that we didn't bring. There are others we didn't have. And so we should have been giving.
Let us go to the rules. Because it was based on the rules that the Supreme Court ruled. So you go to Order 21, Rule 9. They came under Order 21, Rule 9 of CI 47. Order for production for inspection. If a party who is required by Rule 7 to serve a notice or who is served with a notice under Rule 8.1 fails to serve the notice under 7.8 and so on, objects to the production, offers inspection at an unreasonable time, the court may subject to Rule 11.1. So when you read these rules, in fact, Order 21 always has that rider, especially where you are going for a court order. And Rule 21, as we know, when the law says subject to, it just means that the one that is coming after, or the one to which this is subject, prevails over the other. So this whole provision is subject to Order 21.11. Now 11 says an order for production of any document for inspection or to the court shall not be made. It's mandatory under any of these rules unless the court is of the opinion that the order is necessary either to dispose fairly of the cause or matter or to save costs. So you need to show to the satisfaction of the court that the making of the order will ensure that the court itself fairly disposes of the matter, or it will also ensure that, or it will also ensure that there will not be expenditure or money wasted, if you like. And expenditure can even be energy, expenditure of energy, but it's talking about cost. So if you are not able to satisfy the court as far as this threshold is concerned, your application must fail. And you see the danger in bringing applications like this, and I have always tried my best not to go under this application, especially if the case is advanced. There's a danger because the court is now telling you that the production of those documents or whatever, or the evidence you are seeking now, will not enable us to fairly dispose of the matter. That is the other way around. Will not enable us to dispose of the matter fairly or in terms of the dictates of justice. That should give you a signal that you should have, at the beginning, brought all that you required.
Do you take note of something too, that in the 2013 petition,
yes,
when all the 9 justices
yes,
refused the petitioners their discovery, when they were delivering their judgment, 2 of them, Akoto Banfo and Justice Doche, yes, regretted not allowing the discovery because they said some of the pink sheets that they were relying on were ineligible, were error reading, among other things. They were just 2, so they couldn't have overcome. But initially, they granted unanimously, but later in the judgment, they said they regretted it. And the reporter, Bimpom Buta, had reason to criticize them that, that was wrong, and that in future, in an election petition, it's okay to allow for the original documents to be given by the one who has it.
Yes, but that is where the person who is requiring or demanding the original doesn't even have it at all. You see, if you have an entitlement, if you spend that entitlement, refuse to comply or even make the demand, it it is your own problem. But you see, in that judgment, in the 2013 judgment, that was not the only regret. In fact, since you mentioned it, Justice Doche also said that the NDC shouldn't have joined. They shouldn't have granted the application for joinder. That was also another regret. And that is why in the current CI 99, they said that only persons who have concern with the declaration, the validity of the elections, can commence such an action against the declarant, that is the EC, and the person in whose favor the declaration was made. That is why we have the current situation. So that was also a big deal that after evaluating the evidence...
Why didn't you want them yesterday to have their entire witness statement for the third witness to be made? You want everything to be brought out in the open, isn't it? Why were you bent on having the entire thing thrown out? Why?
I said the other time that a party should even be thankful to the other person when matters like this are raised now. To be honest with you, for those who are very conservative, they will decide that, well, let it be struck out. But there are those who are in between the line, that there is quite a large number of some matters that are not supported by the pleadings, but a witness. And in this case, you see, it is a witness. Somebody has filed his petition.
The question the layman is asking is, what are you afraid of?
I'm also a layman.
If indeed something didn't go wrong with the elections, and you are not afraid that by that testimony being allowed, it will change, they will be victorious at the court. Why that spirited fight?
This is a very fundamental issue yet to be resolved. So I'll try and stay away a bit. But then, because I'm conscious of...
I get your caution. Of course, we raised the issue here last week, and it does look like the court listened.
That is why
they issued the appropriate caution to the lawyers.
I said I will always restrict myself to the matters that have already been disposed of.
That's true.
But you see, talking about that, the point is that we all know the importance of pleading. Our court frowns on surprises. So where a person has filed a petition or a case, that person has, in this case, 21 days to think through all that he must bring out as facts, of course, not as evidence. The person now has not taken the option to give evidence himself, nor give power of attorney to another person, which, as I said the other day, no law binds him to it, but consequences may follow. Now, then, a witness comes to court and decides to bring new facts that the petitioner himself didn't find necessary to bring to the court. Seriously speaking, if I debated this matter within myself, and I had serious anxious moments about them, whether I would not have even been silent and write a very copious, expansive addresses or submissions after the case, because there's issue about departure, which is a very important, fundamental, elementary matter that one can address. So I think that when these things come up,
as we talk
we must be thankful to those who raise them.
As we talk about matters in court, let me let you know, and we will give you the full details later, that the MP for Asawase, Muntaka Mubarak, has issued a formal written retraction and apology to the Supreme Court for the allegation that he made about a Supreme Court judge allegedly seeking to compromise one of their members, a lady, over the speakership elections. We will get to that shortly, but let me Dominic, Form 13.
One point before me.
Form 13 is only one copy, isn't it? And it's attached to your. It's attached to your the first respondents exhibit 4.
Yeah, the witness statement.
Yeah, it's attached as exhibit 4 of the first respondents witness statements. Is that not so?
Yes, that is so.
Hello, Dominic.
Yes, that is so. Are you hearing me? Something?
Yes. Does that change the point you sought to make?
No, it doesn't change the point I sought to make. the Form 13 that was, or let me put it, the purported Form 13 that is attached to the witness statement of the first respondent. All right, it's just only one, in our view, one document relating to her declaration. Because the Form 13 that she purportedly attached to her witness statement was the one that was issued on the 9th. And you remember something that our agents were not there. They did not append their signatures to it and so on and so forth.
My question is that it's supposed to be one copy. It's already been put in the court.
No,
so why are you asking for it again?
In our view, there should be more than one Form 13 in this matter. The reason is simply because if you change the results and you declare a new set of valid, figures relating to, a total valid votes cast pursuant to Article 63, there must be a new Form 13 supporting that, computation of the votes. All right, and we want the full complement of documents supporting, her various declarations, the various figures that she made. There must be in-house documents, all right? If public decision-making was not arbitrary, was not just unreasonable and capricious, there must be a full complement of documents supporting the various changes that were made. Okay. You don't, in a public, establishment like the EC, all right, you don't just declare figures by word of mouth.
Okay, now let me bring in Oliver. And Oliver has been observing and joining people like Professor Kwekua Sare and others who are a bit uncomfortable about some of the developments in the Supreme Court. Of course, last week the issue was raised here about the conduct of some of the lawyers, and the court had reason to caution one of them in particular. And that person is not able to speak on the matters any longer. Now, Oliver, as you watch, we're looking at the other side that comes into all of this. They finish a session, and there is a stand for all the parties involved, their lawyers, to go and address the media. And they talk about things that go on in the court, how they are unhappy about some of the things that happen. Chachu, for example, used the word irrelevant to a judge, and some people can't understand that a lawyer will use the word irrelevant. There are some too who say, what else, what word should he use? Irrelevant, if it's irrelevant, it's irrelevant. What do you make of all that?
Thank you, Samson, for this, and I'm happy to join the conversation today. I think one of the things we have decided to choose in our jurisdiction by the recent LI is that we do not want lawyers who are participating in the matters before the court to speak on the matters before the press once they're out of court. That's the choice we are making in our jurisdiction as it pertains to the conduct of lawyers appearing before the court. And so it's something that we have to respect, I would genuinely say, because that's the choice we have made. It does not pertain in other jurisdictions where we've seen advocates address the press after advocating in court. Now, generally, in terms of public commentary, and this is perhaps where I've had the biggest challenge, public commentary on the matters that pertain in the court and the kind of language in which people can criticize or should be able to commentate on the matters. I do think that I'm a bit apprehensive of when people have been asking the court to invoke the powers of contempt in order to shut down debate. And that is where I've had the biggest challenge. I had the same critique of the court when this happened in the last election petition. And as we are seeing now again, these matters come up again. So if it is the respect of the conduct of lawyers and the rules in which they decided to govern themselves by, I think those rules should be respected. But I think that in the democratic setting that we have, generally, people should have the right to criticize the court, even in uncharitable language. It is the ultimate essence of democracy for people to disagree with the court and to disagree with it in colorful language. And I think that it is treating the court and the members of the court as persons of feeble mind to say that they need some particular kind of protection from, or the kind of protection that other branches of government do not get. And I've said, and I've used, for instance, the colorful language to say that it is fair to say that judges of the Supreme Court are either damp or myopic or even biased in the same way in which one is entitled to call the president fat or a thief. And that is the essence of a democratic dispensation that we should encourage. So I think that in terms of how we balance and think about the way in which public commentary on the cases before the court should go, we should be very particular that we do not apply standards that lawyers in their own professional setting have applied to themselves and expect that people in the general public and in a democracy should guide themselves by.
So you don't have any qualms at all about Chachu Chiketa, for example, telling a judge to his face that what you said was absolutely irrelevant?
I think that there's a basis in law for the comment. And I think that we have to situate the comment within the legal context. That in law, whether questions are being asked of a witness or whether evidence is being left, it must have certain probative value. And the language you have chosen to describe that is the question of relevance. So to say to a judge that a question or a statement was irrelevant has proper legal context. And it's not a comment made light or should be treated in a broader contract context where we are expecting certain level of deference to authority, where such language in popular conversations might be construed differently.
So how do you reflect on what people say? You have your hands in the mouth of the judge, and you are saying things that may get them angry, and they may give a ruling against you. How do you process that? Is that how we should be thinking as a country?
So that's a very good question. I think on the one hand, we've given to ourselves the fallacy that judgments or justice is always dispassionate, and that when judges come to it, they put their own personal emotions aside. And so, for instance, when the Ghana School of the University of Ghana School of Law, Professor Tuguba did a research about the political motivations of judges in decision making, it was heavily criticized for. So we need to, I think that we cannot eat our cake and have it. Either we are saying that judges can proceed on a matter dispassionately, or we recognize that they are also humans who are also susceptible to their own emotional outbursts and also emotional mistakes when it comes to view a matter, that they are not always dispassionate. If you accept that they are not always dispassionate, then it bears to reason that a judge could take issue with the matter in which, or the language with which he or she has been addressed by an advocate appearing before them, and on the basis of it, allow that to cloud their determination of a legal issue which should be dispassionately dealt with. That's I suppose, approach in which I would look at it. Right.
You refer to Professor Tuguba's, research, so to speak, and which, Justice Sophia Akufu was so unhappy about, and many judges equally. But if you situate what he did, whilst in America they do that without any problems, should we not take into account our culture? So if you take Professor Epstein, for example, she has written in the US about judicial behavior and trace judges, their idiosyncrasies, their political leanings and everything, and nobody is making any qualms about that. If you read those of the American Realist School, jurisprudential school, they talk, for example, Charles Haynes speaks about judicial decisions being affected by a judge's view of public policy and by the personality of the particular judge rendering the decision, specifically social, political, economic, and cultural movements, coupled with the judge's individual temperament, personal impulses, and lifelong experiences, creates a predisposition whereby certain judges are inclined to arrive at certain decisions. These have been done, and they continue to be done in places like America, but we have a different culture. And particularly when the pronouncements are being made at a time when, a process is going on in the court, will it be the same?
So thank you for this question. I think that one of the things we need to be able to have a conversation honestly about is that we should not equate the lack of research and the lack of interrogation of these matters and elevate it to a cultural disposition. the truth is that we haven't sufficiently researched these issues. And so the fact that we haven't done it doesn't mean that we have a particular cultural disposition to not look into the motivations of judges and why judges tend to rule in a particular way. It's a legitimate matter of research that one could look into. And so, for instance, even in the current law faculties we have, the very times when in teaching jurisprudence we have looked at certain decisions and determined whether the judge had a positivist leaning in ruling on a particular matter or viewed at it from a liberal point of view. And these experiences or different life experiences shape how what judges bring into their rulings. So in this particular matter, I think inquiries into judicial philosophies is a useful exercise. You know, Dr. Ina, I was telling Dr. Ina was my lecturer for administrative law. And there was something he said in class a long time ago, that the best disinfectant of any public decision making is information. So sunshine is the best disinfectant, right? So if you clarify and you go into the rationale of why judges arrive at certain decisions and we understand their motivations and we look at their background experiences, it makes one a better advocate. We're better able to determine why a judge will rule in a particular way. I do not think that there's anything inherent in our culture that prevents us from going on to this inquiry and making those determinations. Okay. Unless we are saying that we want to be hypocritical and say that judges come to the court as blank slates, and so when they come to it, they do not carry forward or carry over their life experiences or the way in which they've lived their lives.
Martin, thank you very much for joining us. Martin Pebu.
You're welcome, Sam.
Great. I have heard it said that for even lawyers to be heard saying that it is only Chachu who can say what you did is irrelevant to a judge. To hear lawyers say that is to suggest that, you know, lawyers go to court and they are not doing what they are trained to do, to be bold, to be fearless, and to be candid and honest about what they do. And that there's nothing wrong with saying to a judge that what you are doing or what you are saying is irrelevant. And to say that it is only Chachu who can say that to the court doesn't bode well, including for people who are getting inspiration to become lawyers. What do you say?
Oh, Sam, it's a very tight line between zealous advocacy and being rude to a judge. You know, we have all grown up with the saying that it's it's easier to catch a fly with honey than with vinegar, right? Yes. But situating it in this context, what I'll say is that Chachu's statements should not be taken out of context. For me, I thought that it was a very healthy banter between them. Let's not forget that Chachu has a relationship with most of those judges. He taught them, okay? So these are students he has groomed. And so we should not expect that he would be overly deferent. No, he would talk normally. These are people he's taught, okay? A lot of whom he's older than, okay? So that usual deference that you and I, being, let's say, some would say we are still bad babies. I mean, I would accept it compared to Chachu and Co. We can't do that. It's not derogatory to say it's only Chachu who can do that. No, we are just facing facts. This is a lecturer appearing before his students. So we don't expect that suddenly, because they have become judges, Chachu has to now change totally and be on his knees. No, he has to be himself. It was a healthy banter, okay? And let's not forget, did you see how Justice Apple reacted when the issue of irrelevance was raised? He was laughing, though I wasn't even watching TV, it was on radio. You could hear he was laughing. He said, let me answer for myself. let me answer for myself. That was when Akutuampa interjected. Sam, do you remember it?
That's right.
Yes, I could hear there was laughter.
Yeah, so he told Chachu that was his opinion. He should keep his opinion to himself.
Great, but before then there was laughter, and he says, "Let me answer for myself. Let me answer for myself." He wasn't angry.
Yeah.
He wasn't.
So what do you say to those who are saying that because of that kind of language, he's doing harm to his case? Is that how judges think? That because they swear to an oath to do justice without ill will or affection. Is that not so?
Perfect, Sam. You've answered the question. You've answered it. So, but we'll admit that on paper they are supposed to do it without ill will and affection, without prejudice, bias, and all that. That's on paper. Yes, but we know that in practice, yes, certain statements can irk a judge and he can do the unthinkable. Yes, we can't run away from it. But in this context,
so can a judge look at a case where the law is plain that the judge has to rule in favor of a party, and then because the judge feels angry, they rule against the party? And that's the impression I'm asking us to try and deal with.
Oh, yes. It occurs. I've experienced one before. Yes, many years ago, at least about 11, 12 years ago. And, the statement I simply made, the judge was expressing some sentiments. And then I said that, my Lord, let's deal with the law. Jesus Christ. He flipped. Yes, that was it. I just said, Lord, let's deal with it. The person was... But
Martin, that gives a very bad impression of however small the number of judges may be who may do that. But is that not the reason there are reporting complaint systems, even within the system? So if I am aggrieved by a judge's conduct as a lawyer, there is a precedent of judges at a certain level that I can report to. And if anything at all, if it gets to a higher situation, I can report to the Chief Justice for some action to be taken. Is that not the case?
Yes, there is. So, Sam, do you know something? Here, I'll say that let's not major in the minors. That's a very small number. So, for me, let's concentrate. The larger majority of them, they know that in an adversarial system, okay, lawyers would have to fight their case zealously. It's not like an inquisitorial system where it's the judge who is basically doing the fact-finding and all that by himself. So in our system, there are bound to be situations where lawyers would inform judges that, no, my Lord, I think you are descending into the arena of conflict. I think Chachu actually said Justice Apple was harassing the witness. Is that not so?
That's right.
Yes. Yes, I think as and when a lawyer feels the judge has crossed the line, the lawyer has to politely draw the judge's attention. It helps. In our various local languages, there's that statement that right? Is that how we say it?
That's right.
That's the English rendition. I mean, so look at it. Almost all the languages that I speak, there is something like that. So it was actually a duty for Chachu to draw the judge's attention that Chachu feels that the judge is descending into the arena of conflict.
So is it fair comment? Is it fair comment for the John Mahama team to say that the bench is not being fair to them?
That comment, don't forget, so this political communication. And in political communication, there are many ingredients, so many things go into it, that even some that I may not understand. So it's to be expected that naturally, once some rulings don't go in their favor, they would say so. Sam, even you and I, every day when we appear before judges will tell you that when you rule for a lawyer, he will bestow all the pleasant accolades on you. Oh, my Lord, may your Solomon's wisdom increase. May you be promoted to the Supreme Court, and so on and so forth. You rule against the same lawyer, and he goes around, he says, oh, that judge doesn't know anything, you see? So it's in the nature of human beings that when a case is going in our favor, we use all the positive.
Okay.
And when a case is going against
so
us,
right, let me take the brief comments of those who are actually involved in this, and then we take a break and return. Now, I know, Dominic, because of where you have been to having been Deputy Attorney General and all of that, and whilst you were Deputy Attorney General, you had cause to complain a lot of times about the content of judgments that were being churned out by judges. President Akufo-Addo has had cause to say the same. I think Chief Justices have to echo the same. That will be said to be a fair criticism of the entire system. But yes. Is it okay for you guys to leave the courtroom, get to the press stand and say they are not being fair to us? Or we have heard that they say they will be balanced, so we are expecting them to be balanced. Is that fair?
I think it's, as Martin has pointed out quite clearly, we are not only doing legal communication, we are also communicating to a political, to our base and to Ghanaians generally. And when we use expressions such as the court is not being fair to us, it is to communicate the fact that we disagree deeply with what the court has said, today. And it is not sufficient for you to just tell the world that you disagree with the court. On what basis do you disagree? How do you feel about the outcome that has provoked the disagreement and so on? So when we say the court has not been fair to us, we give reasons. We don't just come and say the court is unfair and walk away. We give reasons why we think that the court has not been fair to us in the context of the petition hearing and the arguments that we made, the responses from the respondents, and then also, the decision of the court. So we do explain, we put it in context. We are not just being judgmental in terms of just saying that this is an unfair and unbalanced panel, and whether we like it or not, anything we do, they will rule against us. That is not the impression we are trying to create. Okay. If that is the impression people are getting, it's unfortunate, but we situate it in the context of a decision outcome, for that particular day. All right. Thank you. Yes, yeah.
Yes, so I was deeply delighted yesterday that Dr. Ini's team said they had great victory, quote and unquote. Yeah. I think I got it. Because you wanted as many as 23. Pardon? You wanted as many as 23 of their paragraphs to be removed. Well, and you got only 4. That's the quote that we got 5, I think. 5. That was the quote. But I'm saying that at least it was said in public. For the people, as he said, they speak for. To know that the judiciary is not just there to do the bidding of anybody. I mean, if you were a judge, the situation that Martin described, if you are a judge and you put the law and the facts which are clear aside and just give judgment against a client whose lawyer may have caused you to be upset about something, then your decision can easily be set aside. Then also you are violating the oath. And that is not what, in my candid view, that is not what judges consciously do. Again, this whole issue about somebody teaching someone, then very soon some of us will also go to court and appear before judges and even tell the judge, you are harassing my client. And that will be because I have taught the judge. We go to court. We don't appear before persons. Let's not personalize the court. That's why I never in an appeal say the judge and they mention his name Ed. The court Ed. We are going before a court of law. And that is why when we rise, When they rise and we bow, or when we rise and we bow, we are not bowing to the judge as a judge. It is the court, the sanctity of the judicial system.
Okay.
Is what, so just a moment, sorry. So I think that the settled practice I understand is that when you have an issue with a judge, you approach the bench. You don't make your dissatisfaction known, especially in a case where the whole world is watching. You approach the bench together with the lawyers on the other side and go to the judge and say, my lord, I think you may have unconsciously stepped beyond your bounds. So if you may, maybe be conscious of it.
So the judge is as human as you are. So it is possible that once in a while,
yes,
you may not have the patience to do what you just said.
Yes, so what I'm saying is that to make it seem as if it is okay, it is normal. That is my concern. Okay. We may also make a mistake, and in the spur of the moment, you may make that. I strongly believe that if you give Senior Chachu another opportunity, he may not use that term. He may have even regretted saying it by now. I strongly have that belief in me.
Okay, so tell me this, 1 minute, let's go. He found something to be irrelevant.
Yes.
What should he have said? What words should he have used?
You see, this matter is one of the things I am saying, and because of my own personal belief.
No, what should he have? What other words should he have used?
He could have gone to the bench and informed the judge that issues have been set in this court. There's no doubt a judge is entitled. He has the power to ask a witness questions within the parameters of the law. If you think that the question the judge is asking...
He shouldn't have said, you are harassing my client. How should he have said it?
What I'm saying is that you could say so, but approach the bench and tell the judge. That may even be where you may have to choose maybe other language.
All right, we'll take a break. We'll be right back.